Good morning, everyone. Can you hear me at the back? Good. Very nice to be in Leeds for the first Commercial Litigation Conference. And I'm going to start you off this morning with a brief talk on the Quincecare Duty. As you probably know, what we call the Quincecare Duty is the duty that requires a banker to refrain from executing an order when on inquiry that executing that order would result in the misappropriation of funds. It's essentially a gatekeeping duty. And cases of consequence involving the Quincecare Duty are a bit like London buses. You get none for a few years and then 3 come along at once. And in 2022, there have been 3 decisions on the Quincecare Duty, where the court has been required to analyse both the scope and the application of the duty in different scenarios. And the courts that have been required to consider the duty have been across the whole spectrum: the Judicial Committee of the Privy Council, the Court of Appeal, and the Commercial Court. And as we'll see as we look at the decisions, unfortunately, the courts have not spoken with one voice. What is the Quincecare Duty? It's useful to put it in context. It's well established that a bank owes to its customer a duty to provide its services with reasonable skill and care. That duty arises both under the common law of negligence and in the contract that the bank has with its customer under the statutorily implied term under Section 13 of the Supply of Goods and Services Act 1982 or Section 49 of the Consumer Rights Act 2015. Quincecare itself, now a relatively elderly case, was a case where the bank had agreed to lend £400,000 to a company, and the chairman of that company had caused £340,000 of that loan to be drawn down and taken it for himself. The judge in that case, Mr. Justice Steyn, held that it was an implied term of the contract between a banker and its customer that the bank would use reasonable skill and care in and about executing the customer's orders. The judge realised that there was a conflicting duty that the banker was under, which was to execute orders promptly so as to avoid causing financial loss to the customer. And so the tension between 2 duties that might pull in different directions was recognised. But what the judge found was that there would be liability if the bank executed the order knowing that it was dishonestly given, or had shut its eyes to the obvious fact of the dishonesty, or had acted recklessly in failing to make such inquiries as an honest and reasonable person would have made. If any of those 3 circumstances were in play, the bank should refrain from executing the order if and for so long as it was on inquiry by having reasonable grounds to believe that the order was an attempt to misappropriate funds. And so when we look at the Quincecare Duty, it arises in a context where the bank is the agent of the customer as the principal. And the bank's primary duty, everyone accepts, is simply to execute the payment instruction which the customer places. But its duty to use reasonable skill and care when doing so might, in some circumstances, require it to refuse that instruction, at least temporarily, whilst inquiries are made. And the question that is posed by the cases on Quincecare is, what are those circumstances? Where does one draw the line? And there seems little doubt that a bank would be under the Quincecare Duty if it knows that the order is dishonestly given. That's a straightforward application. The real issue is what lesser state of knowledge than actual knowledge will suffice before the duty is engaged. And in Quincecare itself, the language that the court used was that of being put on inquiry by having, open quotes, reasonable grounds to believe, close quotes, that the order was an attempt to misappropriate funds. And as we'll see, the Court of Appeal in one of the cases that we're going to look at, Philipp, said the test is an objective one, and the question is whether the circumstances that pertain in any particular case would put a reasonable or prudent banker on inquiry. If those circumstances do exist, the duty is engaged. Now, because the test is objective, and because it requires the court to ask what a reasonable and prudent banker would do in an almost infinite range of potential circumstances, it's perhaps unsurprising that the law is yet to reach a clear indication of a threshold at which the banker will be put on inquiry. So let's look at our first case, Philipp and Barclays Bank. Philipp and Barclays Bank is a case from the Court of Appeal earlier this year. And the first point to make about it, and this is true of a number of cases on Quincecare, is that it was an appeal against the grant of summary judgment. And so the Court of Appeal were not working from any findings of fact that were made at a trial. The only question for the Court of Appeal was, did the claim have a real prospect of success? And Philipp was an unusual case on its facts. You'll remember that Quincecare was a case about a director who had misappropriated his own company's funds. And that type of misappropriation, known as the internal fraud paradigm, is where most of the cases on the Quincecare duty come from. Philipp was different, though. Philipp was different because Mr. and Mrs. Philipp were two elderly individuals, and they were the victims of what we now know as an authorised push payment fraud. That, as you'll know, is where the fraudster persuades a victim to transfer money to the fraudster's account, usually, ironically, by telling the innocent party that their money's at risk if they don't transfer it from fraud. And Mrs. Philipp, unfortunately, was persuaded by such a fraudster to transfer £700,000, which represented most of her and her husband's life savings, into an account in her name with Barclays, and then onto two accounts in the United Arab Emirates, which were controlled by the fraudster. And of course, the fraudster misappropriated those monies. At first instance, the bank, Barclays, sought and obtained summary judgment on the ground that the duty of care that Mr. and Mrs. Philipp relied upon, the Quincecare duty, didn't exist in the circumstances of this case. The bank argued that the Quincecare duty is only concerned with the proper ascertainment of instructions when given by an agent, normally the agent of a company. They argued on policy grounds that if the Quincecare duty was to apply in the circumstances in which Mr. and Mrs. Philipp found themselves, that would be onerous and unworkable in practice because it would require banks to make inquiries about a much wider range of transactions than they had previously understood they were required to do. The Court of Appeal rejected both of those arguments. They held that whilst the Quincecare duty, the cases on the Quincecare duty had previously arisen in the context of fraud perpetrated on a company by its agents, usually its directors, it could potentially apply to cases where the individual account holder had themselves placed the instruction. The Court of Appeal held that the reasoning in the cases that started with Quincecare and culminated in a case called Singularis in the Supreme Court in 2019 did not rely upon the instruction being given by an agent. And as the Court of Appeal pointed out, taking the bank's argument to its logical conclusion, even if the bank knew as a matter of fact that Mrs. Philipp had placed the order induced by the fraud of a third party, they would be under no duty to take reasonable care to make the payment simply because she wasn't an agent. And the Court of Appeal said that that was an unattractive submission which was wrong in principle. They reaffirmed that the test is whether the bank is on inquiry that the transaction was fraudulent, and the identity of the person making the transaction is not relevant to that issue. There's a useful, pithy summary in paragraph 39 of the Court of Appeal's judgment in Philipp, which says this: the important point is that the bank's obligation is not simply and always to execute every payment instruction of whatever kind unthinkingly. They also rejected the submission that the application of the Quincecare duty to individuals would be onerous and unworkable. They said that the circumstances of Mrs. Phillips' case, the transfer of such a large sum of money, were sufficiently different from the ordinary run-of-the-mill BACS transactions that the banks would undertake hundreds of thousands of times a day to make the difference. They emphasised that the question of whether the duty arises is ultimately a question of what reasonable and prudent banking practice would require at the time of the transaction. Now, if Philipp constituted an extension, or at least a potential extension, of the Quincecare duty, the next case that we're going to look at, RBS and JP SCP 4, was a move in the other direction. This was an appeal from the High Court of the Isle of Man. In that case, the claimant was a Cayman Islands-based investment fund which established a scheme whereby investors would lend to a solicitor in England and Wales to allow them to pursue high-volume, low-value litigation. You may be familiar with the firm and the criminal trial that took place recently at Southwark in relation to it. The corporate vehicle by which the relevant loans were advanced to the solicitors and repaid by them was an Isle of Man company called Synergy, and the individuals behind Synergy were Timothy Schools and David Kennedy, who were the individuals who were recently tried at Southwark. Mr. Schools was convicted. The jury couldn't reach a verdict on Mr. Kennedy. Synergy had two accounts with RBS in the Isle of Man. One was used to pay out the loans to the solicitors, and the other was used to receive the repayments from the solicitors. And the claimant alleged that it was the victim of a fraud by Synergy and by Mr. Schools and Mr. Kennedy, whereby their money was misappropriated by it being paid out of the RBS bank accounts to individuals or companies associated with Messrs. Schools and Kennedy. And the claimants sued the bank, alleging that it was in breach of its obligation to exercise reasonable skill and care, the Quincecare duty. And the Privy Council took care to set out the relevant aspect of that duty which the claimant contended for. And it was this: if the circumstances were such that a reasonable banker would have had grounds for considering that there was a serious or real possibility that the fund was being defrauded or its funds were being misapplied, the bank was obliged not to honour instructions in relation to the accounts until such time as it had made reasonable inquiry and satisfied itself as to the propriety of the conduct of the accounts. The claimant's case was that the bank either knew or ought to have known that the money in the RBS account was beneficially the claimant's. And that, as the Privy Council held, was actually the foundation of their case on the duty of care. And the bank sought to strike out or to summarily dismiss the claim on the ground that there was no pleaded basis upon which the claimant could establish that duty contended for. They considered Quincecare and Singularis, as well as a decision from the Court of Appeal in a case that we'll look at shortly called Nigeria and JP Morgan. and they held that there was nothing in any of those cases to suggest that the Quincecare duty was owed to anyone other than the banker's customer. And that is the point about the RBS case, is that this was an attempt by a non-customer of the bank to apply the Quincecare duty in novel circumstances. The claimant made an alternative argument that the duty contended for was consistent with a duty which had previously been found to exist by the High Court in a case called Barden and Société Générale. The Court of Appeal held that whilst there was dicta in that case which would support the claimant's case, it had in fact been overruled by the line of cases which followed Quincecare and was no longer good law. The Privy Council also rejected the claimant's arguments that the bank owed it a duty because it had assumed responsibility to the claimant, or on the basis that there ought to be an incremental development in the existing case law of duties owed by professionals to third parties, cases such as White and Jones and Ross and Cornters in the field of solicitor's negligence in probate cases. So it follows from the decision in RBS that now really at the highest level, there is no judicial support of an extension of the Quincecare duty to third parties, that is, non-customers of the bank, whether it's put purely on the basis of Quincecare or indeed an overarching duty of reasonable skill and care by the bank. The final case I want to look at is a decision of the Commercial Court, Nigeria and JP Morgan. And Nigeria is an important case because it's one of the rare examples of a decision on the Quincecare duty based on facts found after a trial. And it's also interesting because there is, for the first time in the case law, a querying of whether the Quincecare duty itself has any place in the common law. The figures in this case are exceptionally high. The defendant bank had paid out around £1 billion to accounts held by a company called Malibu Oil and Gas Limited. That company was closely associated with a disgraced former Nigerian oil minister, and they were paid out on the instructions of authorised officers of Nigeria in two transactions in 2011 and 2013. So this was a case of corrupt government officials. And the claimant's core allegation was that the Quincecare duty arose because the bank was on notice that the company, Malibu, and the corrupt officials given the instructions were involved in a fraudulent and corrupt scheme. And one of the principal issues in the case was whether or not the Quincecare duty applied to those facts. And in opening her discussion on the Quincecare issues, at paragraph 145 of the judgment, Mrs. Justice Cockrell cited from an article by Professor Peter Watts, which called for the Quincecare duty to urgently be reviewed by the Supreme Court on the ground that it did not provide a generally satisfactory principle. And the judge used what she characterised as the controversy as to the existence and ambit of the Quincecare duty to hold that there was a requirement to be very clear about what the law establishes and not venture beyond that. Now, given the number of cases there have been since Quincecare in which the duty has been confirmed, whether there in fact is such a controversy as to the existence and ambit of the duty is far from clear. But the fact that Mrs. Justice Cockrell used Professor Watts's doubts to open her discussion certainly set the tone for her judgment. She then went on to hold that strictly Philipp, which had been decided earlier this year in the Court of Appeal, constituted only a potential extension of the duty, expressing the view that the ratio of the Court of Appeal's decision was simply that whether the duty existed or not didn't depend on whether the instruction was given by an agent. Now, that is undoubtedly true as a matter of strict semantics, but it rather overlooks the fact that the Court of Appeal had determined that Mrs. Phillips' case, based on a duty of care that she and not her agent had placed the relevant instruction, had a real prospect of success. And in fairness to Mrs. Justice Cockrell, she did later in her judgment recognise and cite the Court of Appeal's holding that the Quincecare duty applies in any case where the bank is on inquiry, that the instruction is an attempt to misappropriate funds. But she went on to hold that the duty was, open quote, narrow and confined, close quote. That she took from Mr. Justice Staines' judgment in Quincecare itself. In a passage which starts, open quotes, everything will no doubt depend on the particular facts of each case, close quotes. She found further support for the limitation of the Quincecare duty in the judgment of Lord Justice May in a case called Lipkin-Gorman from 1989, which was a case where it was emphasised that the primary duty of a banker is just simply to execute the order in accordance with their instructions, and the circumstances in which that duty would be overridden by the Quincecare duty would be exceptional. Now, just pausing there, it might be thought that if exceptional just means, something different from the norm, then given the very small number of transactions in which funds are misappropriated as compared to the total number of transactions that take place each day, all cases involving the Quincecare duty are exceptional by that definition. But ultimately, having made those comments, at paragraph 158 of the judgment, Mrs. Justice Cockrell gave herself the following self-direction as to the scope of the Quincecare duty. And she said this: firstly, the duty arises in relation to the payment instruction. Secondly, there needs to be a clear focus of what it is the bank in question must be on notice of. Thirdly, unless the bank is on notice that the instruction in question may be vitiated by fraud, that is to say, the payment instruction is an attempt to misappropriate the customer's funds, the duty doesn't arise at all. And finally, it follows from those 3 points that the focus has to be on notice of the matter that has vitiated the instruction and not any different or wider potential concern. So what she was really saying was you have to focus in at a granular level on the matter that is said to have vitiated the instruction, not concentrate on wider concerns. And so notwithstanding the tone of her discussion and her statement that the Quincecare duty was, quote, narrow and confined, I think that none of those points that she ultimately made in her self-direction are particularly controversial. The focus on the payment instruction is entirely conventional. It surely doesn't matter at all whether the banker has general concerns about the conduct of an account, if, according to the objective standards of banking practice at the relevant time, there was nothing to put the bank on inquiry that the particular instruction was part of an attempt to misappropriate funds. So when she applied that focus test and she adapted the Quincecare duty to take into account the agreed position that pertained because of the defendant's terms and conditions, she had to determine whether the defendant bank had acted with gross negligence. And in her judgment, on the facts that she found after trial, she found that there was no such negligence. She found that whilst one of the transactions had unattractive features and an association with past corruption, that wasn't enough to trigger the Quincecare duty. In relation to the other transaction, she found that the evidence didn't establish the obvious risk of the relevant fraud, and so gross negligence wasn't made out. So where are we after those three cases? Well, I think we can summarise the position like this. Firstly, notwithstanding the academic criticism from Professor Watts and others, the Quincecare Duty is alive and kicking, confirmed by the Court of Appeal in Philipp. Its scope has been expanded in Philipp beyond the paradigm case of fraud by an agent on their principal, but a much more far-reaching extension of the duty was rejected by the Privy Council, the extension to third parties in the RBS case. And as for Nigeria and JP Morgan, despite the tone of the judgment, the exposition of the principles ultimately applied by Mrs. Justice Cockrell seemed to me at least to be conventional. Now, given the money at stake in the Nigeria case, it won't surprise you to hear that there is an application for permission to appeal, which as of yesterday had not yet been resolved. So it may be that the Court of Appeal will have the opportunity to consider the scope of the Quincecare Duty in the context of detailed facts found after a trial. And who knows, it may even be that Professor Watts gets his wish and that the existence of the duty is examined in due course by the Supreme Court. Thank you very much.